Okay. I'm going to give everybody just a moment to get logged in, and we will get started in just a moment. But I want to welcome everybody to our webinar today. As you guys know, my name is Ginger. I'm the Executive Director of Connectionology, and we are back with another incredible webinar. You guys are going to learn so much, and I highly encourage you to ask questions so we can make this pretty conversational today. And then later on, you're going to meet two of our amazing partners over at OnPoint Legal Nurse Consulting, as well as Fox AE. But let's go ahead and get started because we have a lot that we're going to be talking about. I'd like to introduce our amazing moderator today. For those of you who do not know, Ilya has consulted in some of Trial Structure's most successful cases over the last few years. And she's routinely traveled all around the United States to work with a lot of the top trial lawyers on large, complex cases. She also has presented at the National Trial Lawyers. In fact, we all just got back from Miami a couple days ago. She's presented for the American Association for Justice, which is Weekend with the Stars, as well as many other programs across the country. And she's done a lot of these incredible trial structure master workshops. I highly suggest for you guys, if you have not heard of Trial Structure yet, that go to their website and learn all about the amazing things that they do over there. That's another company that we love working with. And but I would say for the last 20 years or so, Ilya has represented a lot of the plaintiffs in a wide variety of complex personal injury matters. And that includes dram shop, that includes nursing home negligence, insurance, bad faith, civil rights, abuse, and discrimination, as well as a lot of serious auto crashes that involve traumatic brain injury, catastrophic injury, as well as wrongful death. And she's also successfully prevailed in a lot of claims that involve governmental entities, as well as hospitals, multiple national corporations, as well as heavy equipment and transportation companies, as well as mainline insurance carriers. She's a member of the executive board of the Arizona Trial Lawyers Association, and I believe Ilya just finished her presidency of the Arizona Association for Justice, and she's been heavily involved with them, as well as being part of their board for over like 9 years. And she, if you've not had a chance to catch her speak, you should. She's going to be coming as one of our amazing presenters at our national TBI seminar that we're about to do in Nashville, Tennessee, for the third year in a row. And so that's going to be May 5th through the 7th. And all the information will be on the website today. So I hope that you guys will definitely come and join us so you can hear her present in person. But Ilya, she's incredible. And I don't want to give away too many secrets, but I know, Ilya, you just had a huge, huge verdict. I don't want to talk too much. I'm going to let you do that. But we are immensely proud of this figure that you got for your clients. And I'm hoping that Brett and everyone kind of talk a little bit about that later today as well. But for now, I'm going to go ahead and hand it over to you, and we're going to have a great webinar.
Thanks, Ginger. I am happy to talk about the recent award. I have said and will continue to say that we absolutely would not have accomplished that result without the help of priority responsible funding. And, you know, a lot of times when we're faced with the question of whether or not we want to look into funding or pursue funding, I know a lot of people feel like there's a lot of vendors out there. Sometimes there's a lot of pressure out there. Sometimes there's a lot of folks out there who aren't necessarily on the up and up. And me personally, I felt like I'd had some pretty negative experiences venturing into the realm of case funding and litigation funding, and was very reluctant. And I'm so happy to be able to do this for priority, but also Brett, who through this process has become not only a very esteemed colleague, but also a friend, someone that I've developed a relationship with. And because the relationship that I do have with funding has changed our position, my position as a law firm owner. I'm really, really happy to be able to offer my experiences and the benefits that have been received as a result of companies like Priority. And so, Brett, I just want to say thank you publicly. I've said it numerous times to you personally, but publicly, I will reiterate that our recent $10 million verdict in a nursing home case in Arizona was a record-setting verdict, We absolutely would not have been able to achieve that without the consistent support of Priority, not only on the litigation side, but also in the medical funding side. And we'll probably get into this a little bit later, but I attribute the help that Priority was able to afford to much better care that my client received. And I absolutely believe that she would not be alive today had she not had a lot of the medical funding that she received from Priority. So it's with extreme gratitude that I am here and happy to share the benefit of my positive experiences and let our audience today know what a great opportunity they have to be able to look into this and explore options that maybe they didn't know existed. So to our audience, I will introduce my friend, Brett Findler, who is a trial lawyer who understands very much the demands that we have, the numerous pressures coming from the courts, the opposition, the client very often understands in a way that a lot of funding companies do not, the pressures that we all face. And he has committed himself in the cases that I've been involved with in a manner that's unmatched by so few in the field, anyone in the field, as far as my experience has told me. So, Brett, bringing your 35 years of experience, I think makes you a very knowledgeable and experienced person to talk about what the realistic pressures are for the trial lawyers. So it is my pleasure to introduce Brett Findler to talk about funding and what it can do for your opportunities and options in your law firm. So Brett, take it away.
Well, thank you, Ilya. First of all, it's an absolute pleasure to be here. Thank you for the kind words, but we'll get into it more later. But trial lawyers like yourself, you're the Ferraris that need the fuel to get around the track as fast as possible. And that's what we do. So I want to make it clear, because I love talking about this subject. I'm not here to discuss about Priority. I'm here to teach lawyers what I think is the best opportunity to increase your case damages, winning percentage, and just taking you from David to Goliath. And it can be done. And I know it can be done because I've seen it over the past 5 years. So a little background so you know where I'm coming from. I practiced in Florida for 35 years. Our law firm had 10 lawyers at one time. We had an active personal injury practice. One of the biggest problems that we had was money. So we had sufficient funds, and when I say funds, line of credit, to put what I call the Broadway production on for the A bucket cases. And guess what? When we did that, we got A bucket results. And by that, I mean, we got the best expert witnesses. We got the best visualizations, and it paid off. My problem, which I think is 98% of the lawyers out there, is that as the value of those cases went down, I don't mean the A bucket, but the cases in my office, we didn't have the capital to put that same show on. And guess what? The results were indicative of that. So I was incredibly frustrated when I would be at a mediation, or even worse, at trial, on a premise liability case that had good value, but I didn't have sufficient funds to get the accident reconstruction video that I would have loved to have. And sitting in the mediation, or worse, at trial, that thought process kept coming into my head, interfering with my brain, because I'm saying, I can't believe you didn't get this. Now you're going to have to explain how this accident happened and try to make the jury or visualize it for them, when this could have been done by a professional. But guess what? I didn't have the money. So that was very, very troublesome to me. I wouldn't call myself an egotistical person. I'm far from it, but I think I have a healthy ego. And when I would see other lawyers no better than I, but at large firms, get better results on those cases, I knew it wasn't because of my inability to put the case on. I didn't have the ability to put that Broadway show on. The second issue that I had with my practice was, in Florida at least, Lawyers are not permitted to pay for medical care or medical treatment. We can pay for a diagnostic test, we can pay for a life care plan, we can pay for an MRI, but we can't or couldn't pay for medical care or treatment. So what happened as a result of that? Well, we had to rely on the lien doctors, letters of protection doctors. I say this with no disrespect to any of them. When it first started, at least in Florida, it was a blessing because that was the only way we could get our clients surgical care, medical care, because most of the clients, at least that our firm represented, didn't have health insurance, and they certainly didn't have the money to pay for it. Well, because we litigated our cases as opposed to just not litigating, that ultimately became the bullseye for defense counsel to attack the case. So, for example, great liability, great client. So what would the defense attack? Well, the doctor who performed the surgery hasn't been paid yet. His bill is $300,000. So defense attorneys would attack it in the simplest way, whether it's at trial or in terms of the mediation. So, doctor, let me make sure I understand this. You haven't gotten paid for the surgery. The plaintiff owes you $250,000 or $300,000. So, isn't it fair to say you have an economic interest in the outcome of this case? Because if this jury determines that the surgery that you performed, although needed, was not related to the accident and doesn't award the monies to pay you, how are you going to get paid? Now, the worst thing the doctor could say, and I certainly coached him before or her, is, well, irrespective, the patient owes me the money. The problem with that is it opens up another Pandora's box because they have already discovered this in discovery, which is, okay, doctor, so in your office notes, you reflect that your patient hasn't worked in 3 years. So if the jury doesn't award this money and the bill is $250,000 plus and they haven't worked, how are they paying you? And my second question, doctor, is in situations similar to this, where the jury didn't award money sufficient to pay you and the client wasn't able to pay you, did you pursue a case against your patient? And look, you don't even have to get into it much more than that. They've already impaired the credibility of my doctor. And to sit there and watch it in person was just incredibly frustrating. But again, had no choice because there's no other way that I could have gotten my client's care and treatment. So, long story short, at some point I put all of this together and I said, you know what? I think I could better serve my bar and injured clients and attorneys across the country by utilizing my 35 years and just aggregating all of the issues that I faced during my time and put it into a company, a program that addresses every one of those issues. Because I knew if I could do that, I could make a difference for lawyers across the country, whether it's single practitioners, small firms, or large firms. Because remember, the largest firms with the most money, if they practice in states where they're not allowed to pay for medical care, it doesn't make a difference that they have a bankroll. How are they going to get that medical care paid for? Now, trial lawyers who really spend their time in court, like Ilya, they don't want situations where their client's going to be attacked for all the reasons that I just said. They want a clean representation and presentation of the medical bills. They don't want to have to face that type of defense attack on credibility and so forth. So what they would do is they would get funding for the medical care so that all of that ammunition that defense attorneys would have is taken away. So I put all of that together and I launched Priority. Okay, I'm not going to talk about Priority anymore. I'm going to now educate you, but I thought it was important to give you a background. There was a side reason that I did this as well is I wanted to do everything possible I can to disrupt the insurance industry, who certainly was extremely disruptive to my clients and myself. Did I have moments of glory? Yes. But all in all, I look at it like a casino, at least in my practice. Oftentimes they won more than I. When I say won, I don't mean I was defeated in trial. I mean, they got the better deal on the case, whether it's a settlement or a verdict. The only time I honestly can tell you that I came out whole with the best result was when I had the money to put the Broadway production on. So I'm here to teach you, to educate you, how you can all use this as a means to increase value to your cases. Stand up to the insurance company, level the playing field so that you can then move forward and be a power, not only for your client, but the insurance companies and defense counsel will look at you totally different. And I'm sure that Ilya can talk to that later on as it relates to the case that she had. So before we go forward, first of all, let me explain to you what is non-recourse funding.
Yeah, and that's Brett. I apologize for interrupting you, but
No, sure.
a lot of folks don't know what I know. For me, the funding was sort of a baptism by fire when I first started doing it. And then, as I said in the introduction, I got a little bit burned, and then I started dealing with different players and finding out, okay, I really like this company. I don't like this company. This company will work with me on the front end. This company won't. And so what are some of the things that our listeners should be looking for when they're checking into some kind of funding company? Because there's a ton of options. And why is non-recourse at the top of the list?
Sure, great question. So first of all, by definition, non-recourse simply means that we, a funding company who provides non-recourse funding, stands in the same shoes as the plaintiff's attorney. So just as the plaintiff's attorney cannot be paid an attorney's fee or reimbursed for costs in a personal injury claim, same thing in a non-recourse funding. So the term non-recourse means that the funding company has no recourse against the attorney or the client for the monies that were funded, whether it's $5,000 or $5 million, if there's no recovery on the case. So it's zero risk for the client, zero risk for the attorney. And in situations where, let's say, the result isn't enough to satisfy the funding or the interest, and we'll talk about that in a moment, then as a trial lawyer, I understand what needs to be done. I mean, it is what it is. So if there isn't sufficient money, then everyone has to participate in making it right for the client, okay? So how does a non-recourse funding company get paid? Well, most get paid based upon an interest accrual. And that is the biggest problem that I saw when I first started this company, because attorneys have it's sort of a bad feeling when it comes to interest accruing non-recourse funding. And I think a lot of that has to do with some of the companies that are out there that are providing pre-settlement funding. So pre-settlement funding means that the funding company is providing capital to your client, not the attorney. So for pre-settlement funding, it could be because the client needs money while they're recuperating, or medical care is still characterized as pre-settlement because the monies, while they're not going directly to the client, they're going to the doctor, the surgeon, the facility. But legally, the doctor's bills are being paid by the client. No different than if the client has Blue Cross Blue Shield and Blue Cross Blue Shield pays the money. That's really the client paying because there's subrogation. There's got to be a payback. So that's how most companies get paid. It's an accruing interest. Because of the bad monikers of companies that have been out there, and I am not here to say anything negative, but I mean, I have a wonderful mother-in-law, Okay, but if you just use the term mother-in-law, it doesn't usually get an overwhelming response of, oh, my mother-in-law is great. That's sort of the battle that I had initially with non-recourse and how it works and how we get paid. So how do we get paid? Well, we have to wait until the end of the case. So if you fund the client, the doctors, or for litigation costs and expenses, whatever that figure is, you're not paying interest on a monthly basis because the triggering event, a settlement or jury verdict, has not materialized. So just as the attorney's not entitled to any money while the case is going on because the triggering event of getting a fee hasn't occurred, same thing with us. Everything is paid at the end. So what is it that you do when you're talking about non-recourse? What types of non-recourse litigation funding are there? Well, we already touched upon a couple. Pre-settlement funding is defined as money going at least contractually to the client. When I was practicing, I wasn't a big believer in my clients taking $2,000 or $3,000 for pre-settlement when it wasn't 100% necessary. What I'm talking about today is not that space. And again, no disrespect to that space. What I'm talking about is pre-settlement funding basically for clients' medical care treatment, inpatient facility, TBI facilities that don't accept letters of protection. So I can tell you that when I was practicing, I had no ability to get my client into an inpatient facility on a lien or a letter of protection. Didn't exist. I had no ability to address my client's psychological damages, PTSD, depression. Mom's afraid to take her kid on the interstate because that's where the truck sideswiped her. So I had to leave those damages on the table. And my client would say to me, well, you're addressing my back, and I appreciate that, Mr. Findler, but one of my biggest issues is it takes an hour longer every day because I have to go side routes because I can't drive on the interstate. How come I'm not being compensated for that? Look at that and say, because I can't secure treatment for you to address that. Just as your back hurts, it's not enough to say my back hurts. You need to have treatment to quantify the injury and so forth. So those damages were just left behind. And I always used to say to myself, wouldn't it be amazing if I could address those damages for my client? Not only the damages, but actually get my client the needed treatment, the needed psychological or psychiatric treatment to address those issues. Wouldn't that be wonderful?
And
And
in a case like ours, Brett, where priority came in and was able to provide that pre-settlement funding. So far there's been no settlement, but the pre-verdict funding. That medical care is then provided because Arizona is much like Florida. We cannot pay for our clients' medical treatment. We can pay for diagnostic studies. We can pay for, certain expert reports and examinations and evaluations. But as far as the actual treatment, we're like Florida and we are prohibited. And so in our situation, we were able to secure those lines of funding through our client's conservator. And they were the party to the contract on the client's behalf, and they monitored and secured all of the arrangements for her medical care and continuing care so that she was able to, our very significantly brain injured client was able to get a lot of the treatment that she needed. When she was on Medicare and on Access, she was massively in decline. And that's why I said earlier today that I attribute the care that she got to her survival, because it was a desperate situation because she wasn't able to get the quality care that she needed.
And you're dead on. And I always like to, when I'm speaking, I think it's great to offer the audience actual cases. And of course, Ilya is telling you about a real case, and that's the case that she just got that incredible verdict of $10 million. But I want to give you some actual cases as examples that represent what Ilya did in her case. So we had a client who was a 72-year-old African-American gentleman. He was a panhandler, okay? Maybe not the best, but he was a panhandler. He was on the side of the road, and 3 officers approached him. And from the moment they approached him, from that point forward, the video, the body cam, everything on all 3 officers went blank. The next thing you see minutes later is this gentleman lying face up in a pool of blood and a slab of concrete under him. Now, the case was brought to me by a trial lawyer in Detroit, and his position was, and he's through the client talking, was that they chased him because they didn't like him. And as a result of chasing him, he fell down an embankment and he tripped and he struck his head. He was quadriplegic at the time that the law firm contacted me. And it was the only video that came on was, so the video was blank until, the video showed them approaching him, goes blank, and then the next time you see that, and the officers are saying, buddy, get up. Pool of blood, he's unconscious, get up. And then you could actually see, it was the most horrific thing I've seen. And my dad was a police officer, so I say this respectfully. But one of the police officers was smirking as his co-officer was saying, buddy, get up. So, of course, their defense was he was doing something he wasn't supposed to do. And they claimed that when they went to approach him, he started to swing at him. I mean, really ridiculous. But here's why we were contacted, because this gentleman was in a facility where he was probably, according to the lawyer, weeks or a couple of months away from dying from bed sores, from maltreatment, because he was not someone who had health insurance. And they needed him to get to a facility to get the proper treatment to save his life. To make a long story short, obviously we vetted the case, and these are not easy cases, police brutality, Title 83 cases, but we took it on, and we were funding his medical care for 2.5 years, almost 3 years. It was well over $1 million. The attorney, I'm happy to mention his name, Ben Johnson out of Atlanta, a great attorney. He tried the case and he got a $100 million verdict. It was reported on CNN and so forth. He will tell you, as most, that but for the funding to allow his client to improve so that he didn't pass away is what saved him. Sadly, the client passed away, but from issues unrelated at least to what had happened to him. But at least that client, and I'll never forget his smile when the verdict came in for $100 million. So there is a perfect example of how you use non-recourse medical funding to support your client's need for medical care and treatment. Now, if the lawyer isn't emotionally connected and they're looking at it strictly from a selfish point of view, how can I increase my attorney's fees? Because obviously our attorney's fees are guided by how much we recover for the client. Well, this case wouldn't have even settled. If it did, it would have settled for a couple of million, and that would have gone to whatever medical care, whatever liens was owed by the hospital. He got $100 million, of course, because of his incredible trial lawyer skills, but because the client was alive. And by the way, the life care plan, and we're going to talk about that in a minute, what he was able to impress upon the jury was that we were providing the medical care that mirrored the life care plan. So the lawyer was able to go in front of a jury and say, look, everything on this life care plan that is almost $40 million present value or $30 million present value, this is what enabled him to live. Because look, here's the photos of him before this treatment with the bed sores. Now he doesn't have any of that. Look at the before, look at the after. So now what have we done? Or what has the lawyer done? He's turned speculation into reality. So now when your life care plan is, and we're going to really get into this, but a lot of life care plans, most of the things that are on that life care plan haven't been triggered yet by the time you get to mediation or trial, which leaves the defense with another simple, easy argument. Well, ladies and gentlemen of the jury, the plaintiff's life care planner said, if Mrs. Smith doesn't get A, B, C, D, bad things are going to happen. She's going to trip and fall at home. She's going to go into a depression. She's going to have this. Well, guess what? It's been 3 years since the life care planner wrote that report. Guess what? She hasn't had one of the things on that life care plan. So why should my client, the defendant, bear the cost of something that the client doesn't need?
I think we've all tried that case, Brett. We've all had that experience of not being able to fund the life care plan. And the first defense attack on the life care planner is, well, how many years has it been? She hasn't gotten any of this treatment that you say is so important and so necessary. She hasn't gotten it. And so the jury thinks, well, she must not need it. And it gets wiped out. So yeah, all of us have seen that case, I think, if we're trying cases.
Right. So whether it's a catastrophic care like the one I just talked about, or cases which is more in line with the majority of the ones that I had during my tenure, was I had a life care plan for $5 million. Most of it was for aid and attendant care, CNA, things that, again, we couldn't get under a letter of protection. That defense argument just torpedoed my case. Now, the only argument that we would make, which is the truth, is the family would step in to do all the things that's on the life care. Well, you're a juror now. You say, well, if the family's already doing it, so why should I have to award monies? Look, it's just an easy way to give so much more ammunition to the defense attorney to attack that life care plan. So I came up with just a sort of a cute name, Bring Your Life Care Plan to Life funding program.
I like it. I like it.
Yeah, and what we do is we are able to fund in real time what's ever on that life care plan. So instead of dealing with perception, now you're dealing with reality. It bulletproofs the life care plan, because now a jury is far less likely to take away the very care and treatment that the client or the plaintiff has been receiving and doing well than to award monies for something that they've never received. So you're changing the course of how the case is being the narrative to the jury. And instead of just trying to make excuses as to why your client needs this, now it's your client has been receiving this care, and that's why they're doing so well, right, Ilya? I mean,
and in my case, why she improved so substantially. And I don't want to get too far ahead of this, this topic, but the other area that, and this is in a different line of type of funding, but we were able to do some illustrations in our case that came from funding, very elaborate. And at a couple of stages, our case went on. I will talk about the case at the end. I'm hoping that our members will stick around, because I've got some really great information to share, but I want to stay on task with your discussion. But in our case, a lot of the litigation portion of the funding was used in order to secure some incredible trial exhibits that if you have a complex injury case like I do, like a brain injury case, you absolutely cannot go to trial without those. And even in the, car crash, anatomical drawings are just not going to cut it if you're just using the stuff they have up on Google. So to that end, we have Cody from Fox AE, who has helped so significantly, so many of our members. So I'll let Ginger bring him on.
Yeah, this is fantastic and great timing too. Many of you guys know that Cody has been with us for a while now, and he is just, I don't know, he's killing it out there in the animation, the graphics, the game. Like, you're owning it, Cody. We are so excited that you're here with us today, and we can't wait to hear more and hopefully to show us a few things as well. But for those who are new and watching our webinar today and they want to learn a little bit more about what you guys specialize in, I hope you will be able to share that with us now. Thanks for being here, Cody.
Yeah, no, this is great. And Ilya, hello again.
Hi, Cody.
Brett, you guys, it's good to see you and good to be winning cases with you. And we can only do what we do when we have great lawyers. And so when you've got great attorneys that communicate, that understand case strategy, like Ilya and her team, it's absolutely amazing. And so I wanted to show you just a quick thing here. And here's what surprised me actually about funding. I was surprised that really, really, we're talking high echelon attorneys, the biggest and the best attorneys, they all use funding. And that was counterintuitive to me. I thought, well, would they be financially set up with huge firms, right, to go ahead and finance these things? They use the funding because it's available, and it really helps tremendously. And so I've gotten really good feedback there. And here's a case where we used funding, and I did this case with John Romano, and I just wanted to share this with you real quick here. Because it's an engineering case, it's a medical case, and we want to show you what can be funded. It can be engineering, medical, product liability, anything that tells your story. But what we had was all John had was this footage here at the top left, which was to show a huge collapse. And so what happened, they poured concrete, it put weight down, and then boom, he falls, and this causes paralysis. So we rewind it and we show the mechanism of injury. And then when you zoom in, this isn't an illustration of the injury. Okay, it's not an illustration. It is the injury, because these are real dimensions. And so what we do is we take the CTs and we can reconstruct. And so if you've got a neutral witness, a treater, right, that's in there performing surgery, like a neurosurgeon, many times they'll say, neutral witness, they'll say, hey, this is exactly what I saw when I performed the surgery and I saved this person's life, or I, did this spinal surgery in this particular case. And so we cover the medical, but also, real quick, I want to just tell you something you may not know is we cover the engineering portion of it. And so really complex, he said, she said, but what we did was we found out that the engineer designed the wrong beam. That's the W16 in red. He should have put a W27 and did not. And so the contractors put the beam that was specified in, thinking that the engineer had performed the calculations. And so every person weighs about 197 pounds. And so what we do is we show how ridiculously underdesigned this was visually. And so we're using math and using, people and the weights, real weights of people. That's the correct beam should have held that many people. The wrong beam on the left. And so it's just an apples and apples comparison. And again, the great attorneys utilize this funding, and heck, I get to work with like some of the most amazing people like Ilya and her team and Brett. it's just phenomenal. So I'm really blessed and really owe it to Connectionology for connecting me with all these people. So I'll let you take it away,
I
Ginger.
would say
Oh,
very
no problem.
quickly to James Guster, because I'm keeping an eye on the chat, but to James, he asks, you know, what do you mean by the Broadway show, Brett? But to your comment earlier, and this is part of it. This is part of the Broadway show, is having demonstratives that just literally crush in trial, because it simplifies so much information. Now, without knowing anything about the case, I understand the case very clearly. And of course, it's not the construction company's fault. It all falls to the engineer. It's very obvious. You've streamlined it and made it simple. But, you know, I think when we don't have the resources, right, we go to that mediation without these killer demonstratives showing that we're prepared to go to trial. They don't take us seriously. They know when we don't have the money. They know that we, you know, we haven't lined up the right experts. And now if the case doesn't settle today, we're going to have to go out and line them up. So the Broadway show is getting everybody in line, getting everybody cast, getting everybody outfitted, hiring your director and your producer all up front so that they take you seriously and your case seriously, because they do know, they can smell it when you're out there on a limb and getting a little desperate because you've got, you know, a couple $100,000 or even more of your own money riding on the case or on a line of credit. So
No,
I just wanted to pipe in there.
No, and thank you, Ilya. And I'm going to tell you about Cody, okay? Because I have the benefit, it's a blessing to work with trial lawyers across the country and see all the expert witnesses who are offering their great services across the country. And I can tell you that Cody, what distinguishes his group from others is Cody's an engineer, okay? That makes a huge difference. It's sort of like I'm an attorney who happens to have a funding company, but I'm an attorney first and utilizing those skills as an attorney to offer something in a funding program that relates to other attorneys. Cody's is an engineer. He's incredible with what he does. So let's talk about the case that Cody just showed, right? So yes, if you have a case where your client suffered those injuries, a quadriplegic or paraplegic, I hope you're going to hire an accident reconstructionist as opposed to being sued for malpractice. But here's what happened in my practice, right? So I had lots of those types of cases, but my client was not a paraplegic or a quadriplegic. My client fractured their ankle or their tibia, okay? Guess what? I didn't have the money to go out and hire a Cody. So I had to explain to the mediator or jury how this accident happened. Yes, I had an expert to testify that it wasn't assembled properly or there was a defect, but I didn't have all of the other things that go along with that. So by having the ability to see the accident, see how it happened as opposed to explaining it, that's what I mean by Broadway production. And listen, you want to be the best, you got to learn from the best. Just use your resources and look how firms like Ilya, Brian Panish, Rex Paris, Joe Freed, all of these rock star lawyers, they have many things in common. Number one, highly intelligent. Number two, they invest in their skill set by going to educational conferences and so forth. But you know what the third one is? They bring it every single time on every single case. They don't have the A bucket case and the C bucket case. No, they dress for success every day, okay? They don't put on a Brioni suit for the seven-figure client and then put overalls on for the client that's got $100,000 case. And that's why they get the best results. It's not a secret, okay? And the other thing is when I say Broadway show, it's the visualizations, it's everything. When you see great trial lawyers who have invested in their case, when they're trying the case, it's like a Broadway production. Everything is smooth. You want to know how I was in those other cases? I'm like, hold on, ladies. Could you, okay. I mean, really, you know, it comes off bad, all right? It looks like not that maybe I'm unprepared. I'm not unprepared. I just don't have the production team so that everything flows beautiful, right? When we all watch, I was watching Netflix with my wife last night, and we couldn't get the movie without the ads. And I'm like, I'm not watching this movie. It's got ads, okay? And she's like, Brett, it's not that. Well, it's an interruption. And when jurors are watching lawyers try cases, those interruptions interfere with their flow. It's just that. So by having the ability to put those cases on every single case, you go the Broadway production, you will get better results. I mean, it's just the way it is. But I can't speak more highly of Cody and his team. They're absolutely awesome.
The thing I'll
Oh.
add about Cody's team is they're also phenomenal about working with some doctors who are notoriously difficult to get hold of, difficult to be timely. They're wonderful. I know on our side, I'm so grateful for the experts I've been working with the last few years, but it's tough because you have to have their input. They have to make sure they've seen the exhibits so we can, lay foundation for them, or we can make sure that we'll be able to use them as demonstratives. So we have to get everybody together, and Cody's team is phenomenal with bringing those pieces together, working with doctors, making sure that the exhibits are revised and revised and revised until they meet the doctor specifications. So there's no problems when we actually have to use them as evidence. So another major prop to you, Cody, on that end.
Man, you guys are way too nice.
Oh,
And
it's so true. It's so true.
Just telling the truth, Cody,
True.
we're officers of the court. We have no choice.
Yeah. I mean,
Well,
I don't
hey.
do this for every, I've worked with companies before, and so I'm super, happy with what I got. It's really nice, but your stuff, what I have told my colleagues is Fox AE is next level. This is good stuff. Fox AE is definitely next level. Really creative insights in terms of really bringing the injuries to life. Kind of pointing out to us that our maybe DTI, MRI looked a little happy and cheerful. Maybe we wanted to make it look more anatomically correct. Those kinds of things were, from an engineering side, obviously that's important, but then on the creative side too, you've managed to really bring that. So, and kudos to you. Kudos to you.
Man, well, I couldn't have done it without all you guys just giving me a chance, and you guys have just been so kind. And really, this connectionology thing, connecting so many experts, it's just been incredible. And so I get to meet Ilya, get to meet Brett, and of course, we get to meet Ginger.
Of course, we're all trying to be Ginger.
That's right. That's right. Thank you so much, guys.
Thanks,
Sure.
Cody.
Honor.
Thank you so much, Cody. And please put your information in the chat box so that way everybody can stay in touch with you. And also I'll be sharing that after the webinar today as well. But thank you again for popping in, saying hello, and tell us a little bit about what you guys specialize in. We're going to see you back again on Tuesday, I believe, for another
Awesome.
great webinar. So thank you so much for stopping by today.
Thanks again, y'all.
Sure.
Bye, Cody.
All right. And in a little while, I'll be popping back in so you guys can meet Rachel over at OnPoint. But for now, let's dive right back into the discussion because this is getting really good. So thank you, Brett, and thank you, Ilya.
Oh, of course.
Brett, before we get to back to the topic, we'd had an earlier question from one of the listeners, Joel, talking about making loans to clients in Maryland. Maybe to make sure what the broad application is to everyone, maybe answer that question, but then talk about some of what the state limitations may be in terms of, generally, in terms of what types of funding, the different litigation funding that might be permissible versus not permissible in certain jurisdictions, if you can address that.
Sure. So it's a great question. So you know what? Again, in my attempt to disrupt the insurance industry, all you have to do is whenever the insurance company looks to attack trial lawyers or anything to do with making the case better, that means they're concerned about it. So what do we have? We have a industry, which is non-recourse funding, that is consistently and constantly attacked by the insurance industry on a number of levels, because guess what? They're afraid of us turning David into Goliath overnight. And when I say David to Goliath, I mean a lawyer who's skilled, who's able to handle these cases, but can't use their sharpened blade because they don't have enough money to put the case on. So this scares them. So if it scares them, it should raise your level of interest and say, well, there's got to be something good about it if it's scaring them. I'm not selling you on this, but getting back to Ilya's question. So every state, like with the practice of law, whether it's workers' comp, whatever it may be, every state has different rules and regulations. There are some states that funding companies like ours, we can't do business in because they consider it champerty, or they limit it to something, to an interest rate that is so low that it's impossible for us to do business. But when I say interest rate, so I want to circle back for a moment to the non-recourse. So, sometimes, and I guess it's because I'm a lawyer, I hardly get this, but very selectively a lawyer will say, well, Brett, you don't understand, this is a guaranteed case. I mean, I don't know why the interest rate is what it is. It's a guaranteed case, so it's really not non-recourse. And I could give you a bunch of horror stories, but I'll give you, again, a real life story. We funded a case, almost $1 million over 3.5 years. Rockstar trial lawyer, former president of his bar association, an expert in the field, just an incredible lawyer. The lawyer is the type of lawyer who he wants the money that he has asked the defense for. He's not like I or most other lawyers where if they come reasonably close, no, he feels the case is worth X. Well, this case was an arm and a leg off case, literally an arm and a leg off case. The offer right before trial was $13 million. He explained to them, I repeatedly told you, if I have to go to trial, if I pick a jury, it's 30 million. When I go to closing, I'm going to be asking 60 million, and I've got a $35 million life care plan to support it. They increased the offer to 17 million. Now, as a funding individual, I'm putting on my funding hat, I'm not allowed to say to him, take the money, even though that would secure our principal as well as whatever the accrual of interest. We can't and do not get involved in that. Well, they went to trial and it was a defense verdict. Lost. It's up on appeal because some crazy things happened at trial with defense counsel, but we've already written that off as a loss. So I use that as an example because there is no such thing as guaranteed. It happens. Once you walk into a courtroom, anything can happen. So I want to again circle back to the state. So you have to really look and speak to your bar representative or find out what you can do and what you can't do. On the issue of interest, every state addresses the issue of, can you charge your clients interest? Forget about funding, from your own cost account or your own line of credit. Because I know when I was practicing, we would put our money out there because we're obligated to. We don't take it from the client. And if we were lucky enough to get the $100,000, the $50,000, the $300,000 4 years later, remember, we've lost money on that, even though you're getting it back in full, because you had the ability for that to generate interest and so forth. So most states allow lawyers, as long as you have it in the body of your contract, they allow lawyers to charge clients interest for the hard costs that they're putting out. Again, you need to talk to your bar to find out how much and so forth. There are states in which we operate where the attorney passes 100% of the interest off to the client. There are lawyers that we deal with that do a portion. That's between you and your client. But the point is, despite a funding company, lawyers have that ability, and they should take advantage of that because we're losing money. but yes, you would have to check with your local bar association to see what is permissible and what isn't. One of the things that I really is important that I want to touch upon is, does this work? Does empowering lawyers with expert witnesses, the best of everything, dressing up the case, putting on the best possible case, does it work? And what is the cost in relationship to what you get out of it? So I always love to give this example. Again, you need to look at this as investing in your case. And if you look up the definition of investing, it's you're making a monetary investment in the hope of securing a greater return. No one wants to put money into something and get back the same amount of money or less. So if the math didn't work in this industry, we wouldn't have this industry. And by the way, this industry started 25 years ago in Australia, non-recourse litigation funding. It migrated to Europe, and then it came to the States about 22, 25 years ago. So it's a relatively new type of funding. It initially came over to the States, not in the personal injury world, but more in the high stakes securities and exchange and mergers and acquisitions where hundreds of millions of dollars are being spent on legal bills and so forth. So that's how it started. But again, if the math didn't work, we wouldn't be in business. So let me give you an example of how it works. But break it down very simple. So let's assume you want to sell your home. Okay? So you're going to hire a realtor. And the realtor is going to come and tell you what he or she thinks your home is worth. But you and your wife already know that your home is worth X. I'm going to say $1 million, because your next door neighbor has the same house and they just sold it for $1 million. So you invite the realtor over, they look at your house, you sit down, what do you think my house is worth? And they tell you $700,000. And you look at the realtor and you say, that's impossible. And they say, why? You say, because my next door neighbor has the same house, same exact house, and they sold it for $1 million. And the realtor looks at you and says, I know, I was the realtor. You want to know why they got $1 million and yours is only worth $700,000? They put a brand new kitchen in and they redid their pool. And you say, well, yeah, I know, I saw it, it's beautiful, but we didn't have the $100,000 to do that. Here's the nexus. The house is the case. The investment in the house is the investment in your case. So if you had $100,000 to get a new kitchen and redo your pool, what would that generate? Well, in the example I gave you, it generated $300,000 more. And this is, I'm not going crazy in terms of increasing the case huge, which I can tell you in a story on another case. I'm being as conservative as possible. So the $100,000 is a cost that your client's going to pay on your case because you're investing, you're getting the best experts, you're dressing up your case, right? And what did that do? It increased the case by $300,000. I failed math, I'm not good, but I think I could do this. 40% of 300,000 is 120,000. That's 120,000 in fees that you would never see because you didn't have the 100,000 to invest. But remember, you're not paying the 100,000, your client's paying that. So now the question, the $99,000 question is, how much did it cost you as a lawyer to come to a non-recourse funding company to get the $100,000?
And I'd like to add to that, Brett. When we come back, we're going to invite on OnPoint, but I wanted to add that it's actually more than that, and this is why I kind of saved my discussion about my case, because in addition to securing the benefits of increasing the case value, there have been far-reaching benefits to my personal, I guess, professional reputation, my reputation among the defense bar, that have significantly increased, I think, the standing and the reputation and goodwill of my firm. And I want to be able to talk about that after we get off with OnPoint. So Ginger, do we have OnPoint all set to go?
We sure do.
Marvelous.
We have Miss Rachel joining us today, and we're so excited to have her back with us, you guys. She's traveled to a lot of our seminars as well, and there's just an amazing team of nurses and experts and people that work on their team. We love working with them. And John Romano, he raves about working with OnPoint. He always says he loves their pain and suffering reports, but also he's like, in every case, you've got to have like one of their nurse consultants because they can tell the story so much differently, and there's such an advantage to that. But he raves about you guys, and we think the world of y'all. So Rachel, thanks for joining us today.
Oh, thank you, Ginger. No, and thank you for having us today. My ears popped up when I heard Brett say the life care plans, because I was like, oh, we do those. So
Nice.
OnPoint, we are a legal nurse consulting and full litigation support firm. And we do 5 different programs and key areas that we can help you out in. So we can collect medical records, we do record retrieval and organization. We have a team of specialists who retrieve the records, and then we send them on to nurses who organize and index those, and then we do optical character recognition and get them back to you in a timely manner. We also have a really strong consult program where all of our nurses are US trained, and we match them to the type of case that you have. And we can do chronologies and timelines, any type of case analysis, and point out the strengths, the weaknesses of the case, any missing records, any red flags, or anything like that. We also have a really strong nursing home and long-term care program, insisting in anything long-term care related. So simple thumbs up or thumbs down merit screens. And we also can provide specialized experts who are familiar with the standard cares of guidelines and stuff. Then we also have our damages program, where we quantify damages either economically with our life care plans and medical cost projections, or the non-economic damages. We do great pain and suffering reports, which Ginger mentioned, John loves. And then lastly, the expert witness program. We provide fresh, well-rounded experts in any specialty needed, and they are coast to coast, all clinically active, and located nationwide. So if you have any questions, I'm going to put all of our information in the box. And thank you again for having us.
I want to talk about OnPoint for a second, because I know them. They're a great company. But again, this is exactly what I'm talking about. Lawyers who you are able to hire OnPoint, it makes the case so much stronger. It makes the case cutting edge. It empowers the case. So what happens, most of these companies are not being used because lawyers say, I would love to, but I don't have the money. I'll get right back to you. I'm settling a case, a big case. I'll have the money to do it. So 98% of the lawyers out there, including the way I practice, was they hired OnPoint for their big case. Well, guess what? Every case can be a big case if you dress it up appropriately. Okay, it rises the tide for everything, and that goes to what Ilya was talking about. Being able to present every one of your cases that way, not just the A bucket, but all of them, it will dramatically allow your practice and how you are perceived by defense counsel to be completely different, so that they will pay what you're asking for, because they know that you have the ability to be Goliath. You're no longer David, you're Goliath, and you're going to use OnPoint on every case, and you're going to use Corey on every case, and you're going to be able to dress your case for success every single day. I can't stress it enough, but thank you.
And it is a game changer for sure.
Thank you, guys. Yes, absolutely. I always say it strengthens every case, and I don't think you can ever go wrong adding a nurse to your case. So
thanks, Rachel.
Thank you.
All right, we'll see you back here hopefully very soon. Okay, Rachel?
Yes, hopefully.
All right, thank you.
Bye.
All right, Brett and Ilya, back to you.
Okay, so now I want to get to, Brett has said a couple of times about his comment about David versus Goliath. And in the case that we've been talking about, this is a case called Stith versus Bella Vita. If you do any nursing home case, you'll know it as an Ensign facility. And this was a case that was almost 10 years in the making. It was a case that I personally hung on to. I've told Brett the story, but I hung on to it through a little bit of the skin of my teeth. It came into me when I was working for another attorney who would have taken, I think, the shorter route, the limited insurance proceeds that the facility claimed to have had, and would not have worked up the case. And I would not have been able to, because I was in the middle of starting up my firm. I had a lot of other financial commitments. I had several other big cases at the time that were really, really making things incredibly financially difficult. And we'd had a lot of promises, a lot of romance, candy and flowers and roses for funders to come into the case. And we actually tried a few out, and we were proven wrong. And I honestly think that the difference when Priority stepped in as the primary funder, the difference, I think, is that Brett is a trial lawyer. And I was getting ready to pull my hair out, and I said, I can't lose another funder. Like, it was too heartbreaking. It was creating some degree of unpredictability about the course of the case. And Brett stepped in 100%, and everything that he said about the prior case where the lawyer was turning down, millions and millions at mediation. The funding company should never be in a position that they are directing your choices as the attorney. And I can honestly say that has never happened with Priority. And it's really important that you continue to have the relationship with a funder that stays out of the way, that you don't feel indentured to, because your commitment is always to the attorney. And because Brett is a trial lawyer, he understands that. And it certainly made a difference in our case, Brett. And I love showing this because what people don't know is that the David and Goliath remark is so true, because I guarantee counsel in this case was not used to lawyers who were trying cases the way we were. They had a $900 an hour expert. We had a $900 an hour expert. We had rock star exhibits. Theirs looked like, things they kind of threw together from Google. And it showed. It absolutely showed. And even though me personally, we wanted a somewhat larger verdict. 10 million was record setting for this area in Maricopa County. We do not get those kinds of verdicts here, but it's piece one of our case. We have an entire arbitration that will be handling the adult protective services claims as well as the punitive damages claims, because most of our really great evidence was actually excluded from this trial and will be going to the arbitration portion. But this is, when I saw Brett, he didn't get to see this, but this was a trophy that one of my experts sent with my $10 million necklace.
I love it. I love it.
But it really has affected I think the way I'm perceived in my community. Certainly defense counsel has heard about this verdict. They have seen the caliber of experts that are being brought in the cases that I'm either associated on. I wipe the slate clean and bring on the new experts that I want to have. And it has changed not only their perception of me and the fact that this is going to be a case that's going to be litigated as though it's going to be tried. There's not going to be A bucket and B bucket. This is absolutely 100% an A-list game, no matter what. And it has allowed me the ability to be more restrictive in terms of the kinds of cases I want to take on. But also open up opportunities to other lawyers who say, like, I've got this great case, I don't know what to do with it. And one of my first questions is, okay, is the client willing to look into funding? Because this is going to be a long, expensive ride, and we need to find out, what their expectations are. Because I know with funding, I can certainly go toe to toe with the insurance industry. Without the funding, you know, we're absolutely going to put our best foot forward. We're not going to cut corners, but they are different kinds of practical real life choices. And I think Cody said earlier, Brett, that funders or a lot of even big firm lawyers use funding. And I think part of the reason is it's leverage. Even if you have the resources to be able to put it out on, you know, put out major resources on, you know, 10, 20, 50 cases, doing that as well as bringing your A game on 5 or 3 really big cases that are going to take hundreds of thousands of dollars, it kind of makes sense to at least shift that burden a little bit, and then have funding where it can be obtained. It's just a good idea. It's still gambling. We're still gambling when we go to court. There's no guarantees. I don't know who would ever tell you, you know, this is a guaranteed result, because there's no such thing. But being able to sort of share in the potential losses and sort of balance that out when you have a funder backing has made all of the difference, not just in this case, but in all of my cases, and I think in my career and my law firm in general.
No, I thank you. You know, I'll give you, in light of what you're saying, a lot of firms have grown exponentially because instead of using their line of credit for their own cases, they're using funding. So how is that affecting their firm? Well, first of all, they can now try the case knowing if, God forbid, they lose, it's not their money. But here's the thing. It allows them to grow their firm because now they're using that capital to hire more lawyers, to hire more infrastructure, to be able to handle the cases that they want to do. Because there's only so much money that your line of credit and the banks are going to put forward for your use. So you got to juggle where you're going to use it and what you're going to use it for. So it's really, you know, I love to read autobiographies and biographies, and you know, the wealthiest people use other people's money. You know, I mean, it's just because they're smart enough to understand the cost associated with getting that money enables them and allows them to do things that they're going to profit far greater than what the cost of that is. So again, you know, I'm a big believer in this. This is my proudest moments as a lawyer has been since I founded this company, because I can empower lawyers that are far greater than I, better than I, with the kinds of money that they need. And Ilya is a perfect example. I mean, just an absolute rock star, but you know, she just needed the fuel to get that Ferrari around the track. And while we're talking about Ilya, so here's another thing that funding companies can do, at least we do it, is Ilya is in her company trial structure. What they do is they are consultants on cases, okay? So lawyers, they're good at some things, they're not good at other things. One of the things that Ilya is just incredible and is nationally recognized for is witness prep, okay? So she is available to trial lawyers across the country to use her skills to prepare your witnesses in a way that you can't, because she's just better than you. I mean, it is what it is, right? So she's far better than you. Allow her the opportunity to do that. But your first impression would be, well, how much does it cost? Oh, I would love to have her, but I don't have the money. Stop. Start to reckon. You need to think differently. You know what? I can say this as a trial lawyer. Most of us are mechanized, you know, we're archaic. We do the same thing the same way every single day. And just to take a moment to say, wait a minute, I could do this better. I'll leave you with this one great example. I had a young trial lawyer called me, I don't know, 6 months ago. And he says, Mr. Findler, I heard about you, your company. I have a case, I need a life care planner. I said, sure, tell me about your case. Tells me about the case. And that's one of the things I love talking to lawyers about. He's explaining the case, and I said to him, you have a great case there. He says, yeah, I think so. I said, do you mind me asking you, when I say who you're using as your life care planner, I didn't mean the actual name, but is it someone you use on a regular basis? He goes, yeah, I got this guy, and wherever it was, Detroit, I don't know. I said, okay, no disrespect to him. How much is he charging you? $8,000, right? So here's what I mean by industry disrupting. What would it do to your case if instead of your defense counsel knowing that you're going to get the same life care planner you use, and I'll be happy to fund the $8,000, but what if I were able to give you a list, or you can secure it on your own, of some of the top life care planners in the country? What would that do to your case? Okay, so it's going to cost more. So in this case, instead of it being $8,000, it was $14,000. I said, I'd much rather give you $14,000 to go get the best. So now the defense attorney is saying, what the F? I mean, like, who died and left you money? He says, you know what? That's a great idea. Well, I heard from him like 8 months later. He goes, Mr. Flynn, exactly what you said. My defense counsel was like, where do you get the money? Because it was someone from Boston, and they flew him in for the mediation. The case settled for double what he would have settled it for. You know, there you go. I mean, it is what it is.
Fantastic. That's absolutely fantastic. It is an absolute game changer. And for anyone who hasn't tried it, I encourage you to reach out to somebody who's had experience, positive and negative. Know what to look out for, because not all companies are created equal. The relationship that you form with the funder ideally is going to be one that's over the long term and not just this case. So, figuring out what your options are and who you want to, have alongside you on that road is really, really important. One of the last questions I had for you, Brett, was really about this, because I love your story. I love how Priority got started, and your passion behind it, behind making this available to lawyers, because I think that's something that's really getting lost. We see, and I know I've just recently seen it in a current House bill in Arizona. We see a lot of people trying to limit, options, but really Priority has been there to create options for lawyers. And if you'll always think, well, I'll do it on the next case, or I'll do it on the next case, or it doesn't make financial sense in this case. The financial sense Brett has been talking about, because it's an investment, right? You spend the $100,000, but you're going to be able to recover ideally 300 or 400 or 500,000 with that 100, because you're parlaying it into something that's far greater. But one of the questions that I had for you, Brett, is what are the things that folks can look for that are the markers of a really good funding company? What should they be when they're out there researching the internet, or seeing vendors at some of the seminars? What are the things that they should be looking for that will help them make a decision about the right funding company?
That's a great question. I mean, look, I founded this company 5 years ago, and I mean, I'm blessed that we're in 28 or 29 different states. We don't have marketers. We don't have a team of marketers. Everything comes in organically. We support educational groups. But I think what it boils down to is that lawyers like to speak to lawyers when it comes to talking about their case. And when you're asking for money, especially if it's a significant amount of money, if you're not speaking to a lawyer who understands what you're talking about, and you're just speaking to someone who's taking notes, who's going to bring it back to the company they work for, and you might hear back 2 weeks later or 3 weeks later, that's just not good enough. I mean, you need to find the company, number one, that you can be assured is not going to exit the war in the middle of the war, because that's the worst thing that I think can be done to a law firm or a trial lawyer. And I certainly heard that many, 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 many times when I first launched this, like, yeah, I know, but when things go south, you need a firm that's going to be a company that's going to be your partner. When I say your partner, have nothing to do with your case. We're blessed that we have trial lawyers and great trial lawyers who want our opinion. because they recognize that our trial team has so much, because everyone on the underwriting team is a trial lawyer. So they want to interact with us. Happy to do it, but we don't do or say anything unless they ask. So I just think you need to have a company that you know how they operate. Does it fit your guidelines? Are they doing it on a factoring basis, which is a whole nother conversation where the bill is X, but the company is only paying Y, and then they're Y, or it's whatever works best for you. I created these programs to mirror the issues that I had when I was practicing. I wanted a real bill, not a factored bill. So when I would go into court, I didn't want to have any issues as it related to the bill. So what we do is whatever the bill is, we pay the cash rate. So the lawyer wants to have his client have surgery by a non-LOP doctor. It's $50,000. We pay the $50,000. The bill has been paid by the client. The bill is the bill. There's no issues. Those are the things that I think you need to look for as it relates to companies that you're trying to, and there's great companies out there. I mean, it's just, it's a partnership, and you just have to blend and work with someone or some company that you feel comfortable with.
Yeah, it's definitely true that I think it is a relationship kind of business. And the one thing that I'll say too is, Brett brought this point up earlier about attending national seminars and being part of that circle. Part of the reason that we have this connectivity with John Romano, that we have the connection with Fox AE, with OnPoint, with our vendors, it's really, for me, I think my reluctance was always, I don't want to come across like I'm doing a commercial, but what I have found is that this is a very good network. It's such a great opportunity to meet people at a much higher level. Like, I started my career like a lot of lawyers. I was trying, cruddy fender bender cases, one right after the other, mostly losing, mostly getting, kicked in the pants, and then learning the hard way about how to try cases, what the evidence problems were, what I needed in order to actually start winning cases. And going to national seminars, being around other trial lawyers who were trying B cases like they were A cases, and getting those kinds of recoveries, I started to realize that it wasn't by accident. And they were using this guy. Okay, I'm going to use this guy. Oh, they were using this life care planner. I'm going to try using it. And I got out of the Arizona box of these are the only experts I'm going to use because this is what I grew up around. I started to see the benefit of having sort of a national practice and national connections. And so now when I'm faced with an issue, of course, I go to my trial lawyer listserv, but I also reach out to, attorneys that I know in Lafayette or, in Tampa or, wherever we may be. And it makes such a difference. It's been so impactful to be able to not only establish these connections and use them on cases when it's actually needed, but then also to, to just have it as part of my community and in my arsenal. It's raised me to an entirely different level altogether.
No, it's so well said. And one of the things that I wanted to do as part of this company is not only impart capital, but to become a resource center for lawyers. So over the 5 years, we have amassed an incredible collection of some of the greatest expert witnesses across the country. And we love sharing that with our clients. Whether you fund it or not, it doesn't make a difference to me. If I can provide a lawyer with an expert that they had no knowledge of, we're happy to do that. Because again, my primary goal is to disrupt an industry that I don't like to use the word hate, but that I have disliked over the course of my career. So
I'll use the word hate. I hate that. But thank you so much, Brett. I'm actually going to reach out to you because I didn't know you had that list, and I'm going to reach out to you. I have an expert I'm on the hunt for.
Whatever you need.
Thanks so much.
I was just going to add to that, Ilya, is like, anytime I travel and I go to some of these conventions and I'll run into Brett, he's constantly pulling me away, him and his brother Lloyd, to go meet some amazing attorneys that I had never met before. And that only just helps all the way around, you know, because we get them out there into the circuit of meeting our group and then coming to speak at our seminars and like sharing the knowledge. So Brett has introduced you to some really great people. I highly recommend if you see him, go say hi to him and just kind of tag along a little bit.
Friendly and personable, and his
Yeah.
wife is just absolutely lovely. But
Yes.
yeah, I mean, these are friendly people, and they're eager to share their knowledge, and you know, because we all have to start from somewhere. And you know, if you go to these conferences and you're, you know, willing to step out of your box a little bit, yeah, people like Brett, I mean, they're rare, but they will make sure that you make the rounds and you become well known and you rub elbows with people who are willing to share some wisdom with you.
I
Absolutely.
appreciate that so much. You two were great. Listen,
And you're
it's a
right.
team. You know what? It's a team.
It is.
That's what it is. We're a team, and we get stronger as a team, not weaker. So it's just a blessing to know both of you and to work with both of you. So, and it's been an honor and a pleasure, Ginger. And thank you, Ilya, for being an incredible host, and wishing
Anytime.
everyone the best.
Anytime. Happy to spread the word.
Thanks
Well,
so
guys,
much.
I have thoroughly enjoyed this. If you give me just a few moments, I'm going to be emailing all of our attendees a copy of this contact sheet so that way you can stay in touch. Be sure to ask, you know, Brett, you know, ask Ilya if you guys have any questions you think of after the webinar. And then Ilya, I also included Brad, his email, because again, you guys go check out trialstructure.com, all the cool programs that they're doing over there. Brad is the executive director. He will answer any questions that you have as well. And of course, if you come to one of our seminars, you'll be able to meet Brad as well as the entire team of great lawyers who work with them. So highly suggest you to check that out. And then also please stay in touch with Rachel over at OnPoint as well as Cody the Fox AE. And then also we are going to add this webinar to our YouTube channel. So give me a few minutes. I'll be working on getting that uploaded. And if you guys think of anyone else that you would like to invite to speak, if you got a cool topic, please reach out to me, ginger@connectionology.com, and I will work on getting that all set up for you guys. Ilya and Brett, thank you so much for being here with us
Thank
today.
you.
I already see these wonderful comments coming in from all of our attendees. Thank you guys. You're making
Thank
me
you so
smile.
much.
Thank
And
you.
reach out to Ilya for trial structure. Don't tell me you can't afford it, because we'll fund it, okay?
Oh,
She's great.
awesome, Brett. Awesome.
All right, everyone, you take care.
Thank you. You
Thanks
too.
All right,
so
guys.
much. Bye-bye.
Thank you guys
Bye.
so much. Have a great afternoon. We'll see you back
Yeah.
on Tuesday. Bye,
Bye.
everybody.
Bye-bye.